And then on behalf of the people, Your Honor, the people waive any potential conflict between this honorable court and the office of the public defender. While the people don't believe such conflict exists, the people make this waiver for avoidance of all doubt.
Ron Brown appearing on behalf of Washington County Public Defender's Office, joining counsel.
All right. The court for its part also does not believe there's a conflict either under Michigan court rules or the cases decided thereunder. To the extent a conflict does exist, given the waivers, the court will consent to hear the matters. Court does call the case of the people versus, is it Quadir Man?
He's in custody, Your Honor.
Call. Okay.
And on behalf of the people, Your Honor.
Quadir Man.
Ron Brown appearing on behalf of Mr. Mann.
Your name, sir?
Quadir Man.
Thank you. What are we doing?
Your Honor, I'd ask the court to set final settlement conference. Is that for Friday?
Would the people be ready if I said it that quick?
That's fine, Your Honor.
Jury final settlement conference will be February 6th, is it? 2026 at 9 a.m. Jury selection, if necessary, would be February 9th, 2026 at 8:30. Both of those proceedings are in person.
May I address bond, Your Honor?
You may.
Your Honor, my client obviously is currently housed at the Washtenaw County Jail. There was some problems with his bond and you revoked it.
There was problems with bond or his behavior.
Behavior while on bond.
That's correct. He was violating his no contact or red contact as a victim from jail, which he is continuing to do from someone else's pin. I don't know this through her listed number, and she identifies them by name.
This catches counsel by surprise, Your Honor.
I'm sure it does.
Because my information is his phone privileges were revoked. And
Which is why he's trying to use somebody else's pin. And now it's going to be the next step for the jail where he's just going to be completely isolated.
this is all new to counsel. He spent his birthday in jail. He has a special needs daughter that he is supporting, Your Honor. He was gainfully employed at the
Mr. Brown, I will be more than happy to listen to you, but I'm not going to do anything if he's continuing this contact.
Message received, Your Honor.
So at this point, motion for bond reduction or any change is denied. Bond will continue. Thank you.
We'll see you Friday, sir.
It's okay. It's okay. That's affectionate what we call around here. You got Zended. Court does call the case. We'll wait. Yes. You're a noun.
She doesn't have anything to say. She's probably got to be her camera off unless you need something at the county.
Yeah, she's here, but I don't.
Yeah.
Court does call the case of the people versus VJ Dandamoody.
Alexander, on behalf of the people, Your Honor.
And good afternoon, Your Honor. Attorney Matt Hauser here on behalf of Mr. Dan Damoody.
Your name, sir?
DJ Dandamoody, Your Honor.
All right.
Teresa Twitter on behalf of probation. Your Honor, Mr. Vanderwood is before the court for a violation of probation hearing. This hearing has been adjourned out, given that Mr. Vanderwood had pending cases at the Supreme Court. It's my understanding that Mr. Vanderwood pledged in the case where he was continuing to send messages to the victim that's in this case, and he was charged with aggravated stalking. He's scheduled for sentencing in that matter on March 11th, 2026. I do know that he had the other case where it was a deferred. The information I have, Your Honor, when I provided the reports to the court is that he was sentenced to 6 months jail on that case. However,
On the circuit court matter?
on the first one.
The first one, okay.
Okay, however, I have since learned that there is more to that. And the prosecutor can update the court as to that.
And Your Honor, in his so Mr. Dandamudi was sentenced on the deferred case, and there was a recommendation for the 6 months. However, I believe, and I might be summarizing, we came to the conclusion that Mr. Dandamudi will be continuing with probation on that case, and then will be able to be released to mental health inpatient treatment once a bed is available. He then, in the new case, pled, and if I could put that on the record, just so the court is aware of what that was,
Sure.
he pled no contest as charged in that case with an agreement to no upfront jail. There was also an agreement for the following terms to be included in his probation. He will do a 5-year term with no early discharge. He's to be released to inpatient mental health treatment with a tether. Once inpatient is completed, he's then to be placed on home confinement at his parents' residence. He's not to use the internet except for documented medical visits. He's to continue with all mental health treatment as recommended by his professionals and to be involved with CMH. He is not to object to an extension of the PPO, and he's to follow all other terms of probation. So there is a plan in place, and I believe through that plan, in his deferred case, an agreement that he would be able to be released once a bed is available with a tether to inpatient mental health treatment, which Mr. Hauser has provided documentation as to where that would be, and I believe it's out of state.
Mr. House.
I guess all that is accurate with one correction. The inpatient Pasadena Villa would be in-state. There is an appointment at the Mayo Clinic on February 16th over in Minnesota. That's the only part that is out of state. Beyond that, as relates to the 2 cases pending before the circuit court, that is a fair and accurate statement. It's also my understanding from Pasadena Villa that a bed is now available. So once we address the hearing today, the last matter before it needs to be addressed where we can get him there would be the bond in the new circuit court case. As that remains at 50,000 cash or surety is my understanding.
In that case, Your Honor, he is scheduled for sentencing on March 11th.
That is correct.
Okay. So I guess what I'm concerned about is how's he going to, because he has about 160 days left on my sentence.
Yes, Your Honor, and probation did recommend to the court, given that Mr. Dandamudi continued to have contact with the same victim, he's been charged and now convicted of 2 felony convictions of aggravated stalking involving this same victim. The recommendation for the probation case here is that I'm asking that the court revoke his probation. Probation is also recommending a jail sentence of 365 days in jail with credit for 204 days served, that he served the balance, waiving all remaining terms and discharging him from probation without improvement. I do know that counsel did send to the court to consider allowing release to the mental health facility. I did provide that documentation to the court to review. I do also, Your Honor, however, know that the victim does oppose that.
Opposes what?
Any release. She would ask the court have Mr. Dandamudi serve the jail time.
And if I may, Your Honor.
Right. Yes, go ahead.
Thank you. Yes. So, and then the request from the defense would be is if the court was so inclined to revoke probation and terminate the probation order from this court, that the sentence be credit time served for I believe the 204 days, because then that would allow the matter to be handled through the circuit court or orders in the 2 cases pending up there, and would allow Mr. Dandamudi to get to the inpatient facility a little bit faster. Thank you.
Just so that, Ms. Valero, so that I'm understanding and I realize she's available, and I'm not asking that she necessarily speak to the court, but the victim in this case really opposes, in some respects, what the circuit court would be doing also, because it would be release.
Correct. And Your Honor, she is aware, I did speak with her, that the request was made that he be allowed to be released to treatment. I do understand, Ms. Hodges' position, given that things go well for a period of time and, you know, it is instilled fear in her. So, you know, that the contact has continued not just once, but then again. So I do understand that she is torn with, that happening. But her preference would be that he serve the remaining jail time.
Well, I don't know. And Ms. Zenda, what you relayed to the court is what's been agreed upon for sentencing in the circuit court matter, correct? So the reality is that's going to happen. And then the only thing that might stand in the way would be if I impose jail time, keep him there, he then doesn't get released to treatment. Right? I mean, that's
I'm correct, Your Honor.
how I see it. Okay.
And Your Honor, just to make sure that the court is aware, when I spoke with Ms. Hodge, I was not aware of all the requirements that go with the release to treatment. So I'm not sure that Ms. Hodge, and I'm not sure if the prosecutor's office confided with Ms. Hodge about what that would entail. But it's my understanding, if he were to be released to treatment, that would be on a GPS tether, inpatient. Then once, and if he gets released from there, he would go to his parents' home where he would be on home confinement. So I'm not sure that Ms. Hodge was made aware that maybe Ms. Zenda can
And
speak.
that's correct, Your Honor. We did speak with her. I spoke with her along with one of our victim advocates on what we were looking for into kind of this whole plan. So she was made aware of what we were thinking about for these plans and what we ultimately ended up.
Okay. I see it at least from the time of the sentencing, but it was before that in November of 2022. We've been dealing with Ms. Hodge and, well, with Mr. Dan Moody and this case. And, you know, it was regrettable to me, certainly with this last violation. Well, not just regrettable, it was disgusting what had come back to the court. I'm not going to just wash my hands of this. I mean, because frankly, with what Ms. Hodges had to go through, and her families had to go through, I'm just myself not going to wash my hands of it. I'm just not doing it. So what I'm going to do in this case, since he's not going anywhere anyway, I'm going to adjourn. My sentencing is March 11th, or DV right after that would be. That's it in March?
March 2nd, March 9th, March 16th.
16th? All right. What I'm going to do is I'm going to adjourn this to March 16th. I want to see the structure of the circuit court sentence. My intention will be understanding some jurisdictional issues would be to match that sentence. And so everyone knows the reason that I would do that. And it may be the best that I can do for Ms. Hodge in this case, is that should there then be a violation, he's going to have to come back here to answer to me. I'm not just going to end this and let him go. If he enters into that behavior, he's gonna come back here and I'm gonna, everything I have will be coming at him. So we're clear as to that's what the court's intent is on doing this. So I'll adjourn this out to March 16th. I'm not gonna do anything on this today. Ms. Polari, you can have the discussion with Ms. Hodge and understand that, and also just go through. I'd like more of a clarification once she sees the whole structure of everything that the prosecutor explained, what her feelings on that might be before I make any further move.
Okay, I will have a further conversation with you.
And Judge, just so we're clear, if I may,
Yes, sir.
as relates to the potential for the inpatient release under the circuit court agreement, is this court opposed to release before the 16th, or would we be okay?
I am not, at this juncture, I would say I'm not opposed to that. However, I'd like my probation department to have that thorough discussion with Ms. Hodge so that she understands that and the reasons for it. She may, at least as I'm hearing. But also, I'm not gonna, as I sit here right now, I'm not opposed to that.
Okay,
Okay, but
thank you.
I want to hear a little bit more vis-a Ms. Polaro from Ms. Hodge, or if she wants to speak to the court directly before I do anything. So I'm not opposed to it, counsel. I guess is my short answer to it.
All right, perfect. Thanks, Judge.
All righty. Thank you, folks.
All right, enjoy the rest of the day.
You do the same.
Thanks, bye.